individual text messages, and I want you to be focused on whether or not they are being offered for the truth of the matter asserted, and if they are, what your positions are, and see if you can make some headway on this.
Thank you, Your Honor.
Oh, Your Honor, the only other thing with respect to the messages, and this could be an email instead of, I just wanted to, we can certainly check, but if I could have the government verify if the messages they are proposing to introduce between Mr. Walsh and the other witnesses, if they have been edited at all, because we have like pages of text messages over a couple days to various witnesses, and I don't know if that is just the chunk that they are taking, or if they went in and cut out any messages.
Okay. And by the way,
I'll talk to the counsel afterwards.
Okay.
by the way, this motion that I'm talking about, we started to talk about Mr. Fasto and Anna Walsh's text messages. But to the extent that they're the defendant's text messages, which were the subject of this, then that's in a different bucket in terms of evidentiary ruling. Maybe not as important to you either, which is why you went to the other.
Right.
Okay. Commonwealth number 15 is to admit internet history from devices in the defendant's residence.
Your Honor, the government has produced 2 binders that they expect to introduce into evidence. One is a binder of the gray MacBook, and then the other one is a binder of Oh, okay, we have 3 now.
All right?
We appreciate that.
Are these for my own, sorry to interrupt you, but are these similar, if not the same, from what came into grand jury?
They're not the same to what came into grand jury.
Okay, because I'm familiar with those from the prior briefings.
This is significantly more material than what came into the grand jury.
Okay. Is it the same sort of format, though? There's a search and then the result of the search?
No, Your Honor, this would, I would suggest, be from a Celebrate report, and we have copies here that we can give to the court to review.
Okay.
But the Celebrate report for the MacBook pulls from 2 different databases, so you see the same search twice or the same visitation twice.
So let me ask you this. I have some questions that I need to process in my head.
Yes.
The searches that are done, is there forensic evidence that shows that the searches were done on the MacBook Pro
Yes.
and not on the iPad?
Yes.
All right. That's what I suspected, but I haven't asked and nobody told me that. I assumed that that was the case.
Yes.
Because that was not the state of the evidence, as you know, at the time the case was indicted.
Yes, Your Honor.
So, and from that time, and that is March of 2023 when the case was indicted, are you saying that the forensic work has uncovered additional searches beyond what was known at that time?
Yes, Your Honor.
Okay, and what's the volume of that?
So the MacBook report, that report that was generated is approximately 1,000 pages long.
Okay. Is that where this search, I hate to be so graphic, but well, it's not that, this isn't that graphic, but this, in paper number 201, I learned of a search that I had never seen before, which is
We're objecting to that one.
right,
Okay.
so that was not part of the grand jury.
It was not part of the grand jury.
What is the date of that search?
That is, I believe, forgive me because there's so many, but I believe it's in and around Christmas.
So
It's before
January 1st.
Yes.
Is it around the same time as the divorcing?
Yes, Your Honor.
Around the 27th?
If I may, I have a cheat sheet for myself.
1227.
It's 12/27, Your Honor. And it is approximately 8 hours before the searches for divorce.
So, Your Honor, there were more searches and hits in general on this topic, as you might see on someone's device. This particular search, the name was, it was also about having a threesome and impregnating someone. There's multiple searches for porn. He is an adult male. So I think to just cherry pick this one, and
I don't care about the porn part, so to speak. I mean, it's inflammatory, but it's the second part of that search, cheating wife. So that goes to the issue that we just talked about before, about his state of knowledge and what reasonable inferences can be drawn from that search being done on the 27th. That goes to that is an argument with regard to his state of knowledge on the 27th as to whether or not his wife was having an affair, right? I could care less about the porn part of it.
No, I understand. I think, but without getting into a semantical discussion about pornography, I think that there's millions of different interests, predilections of what people
Sure.
might watch or like, and I think that it wasn't just cheating wife. It was cheating wife has threesome and gets impregnated. So to say that could have been ancillary to what the content of the material was. So I think it's inflammatory. So when the
Right.
court...
So there's this body of evidence of searches now that are not in my mind because they were, and it's not that it's inappropriate, that's why we have these hearings. But what would be helpful to me is if the Commonwealth, A, can provide me with those searches, and B, if you know, and it's not too much additional work, identify, and maybe it will become apparent to me because there's only the list of what you knew at the time of grand jury is pretty much encapsulated both in the grand jury transcripts but also in the affidavits.
Your Honor, we're prepared to give you the binders and a list of the items that we would seek to elicit at trial from the binders.
All right.
And we'd give that, of course, we've given the binders to counsel, but whatever we give to the court, we give to counsel.
And then if there are particularized searches that the defense is objecting to, I know you will raise them with me. And as a matter of logistics for how the jury is going to be presented this is even the stuff from grand jury, which I printed out because I'm still old school, is binders worth of materials that I have still with me. How are you going to present this to the jury?
So, Your Honor, we have, that would be tagged as an exhibit, a binder, but then it can be
Viewed.
broadcast on these different monitors. So we can ask the witness about a certain entry in the report and put the entry on the screen and then have the witness testify from the screen saying this is what occurred in this entry according to the report.
All right. Just an awful lot of material for them to absorb.
We understand that. It's also important material to the
I
Commonwealth's case.
understand.
And so it's not an easy examination, but we do believe that it's important, and we've tried to make it as streamlined as we can.
All right.
Your Honor, too, just so the court is clear, I believe the government's position is that they're going to put in 3 or 4 actual binders into evidence, so the jury is going to get a giant binder of 1,000 pages. And so at what point does that become cumulative and prejudicial when they just drop by? And I'm just trying, is there a way to streamline this, or is there a way to cull some of it? Maybe that's something we can all work on. I just wanted the court to be aware that that is the intention.
More to follow.
More to follow.
All right. Paper number 16, to introduce Axios Investigations, hired by Diane Walshe, December 28th, 2022. Defendant is opposing. So what is it? Is the Commonwealth just seeking to admit through a person presumably that comes from Axios, because Diana Walshe is not on the witness list?
Yes, Your Honor.
So,
We listed her as a witness, Your Honor. We don't know if we're going to call her, but we did list her in an abundance of caution.
all right, I'll make sure that she's,
I apologize, Your Honor.
I don't think she's on there.
It
She's
could
not
be
on
a
the list.
clerical error, but
Okay, so keep that, so
It's
that,
also present in the court right now, Your Honor.
well, do you want to do anything about that?
I didn't know she was on the witness list, so I didn't move to, I didn't move to sequester her for this hearing. So I didn't understand that she was going to testify, Your Honor. I apologize.
All right. So,
I can tell you what I would intend to introduce at trial from Axios. It's just very simple, a contract that was executed.
right, which I've seen.
Yes.
It's a grand jury exhibit.
Yes, Your Honor.
What's the objection to that?
So, Your Honor, what's the relevance of someone who the government isn't calling as a witness to introduce something that they did on the 27th of December?
Well, the relevance, and frankly, I'm going to ask that Ms. Walsh leave the courtroom.
Thank you, Your Honor.
I can speak more freely.
Thank you.
So, Your Honor, the evidence that the government has provided us suggests that Diane Walshe contacted Axios Investigations on December 27th through email and phone calls, that she signed the contract, that she paid for it. In the grand jury testimony, Jeremy Dozier states that Diana Walshe specifically said, "I don't want my son to know about this." So they're trying to basically say, she did this, we have no evidence that he was part of it, knew about it, directed it, paid for it, and it's just prejudicial and
But there,
inflammatory.
I read somewhere, and it has to be in the grand jury, I read somewhere that the connection to the defendant is that she wanted to do this for some time because of the psychic, and that she went to the defendant or said to the defendant, "I want to do this," and that he tried to rebuff her and say, "No, I think his words were, Anna's a good girl, and, she's not having an affair," something to that effect. But then I also read somewhere, it has to be, again, in the grand jury, that he then gave her the name of Axios. So even though he said, "Don't do it," he gave her the name of the company that she hired, right?
So if the government is going to elicit that information,
The only way that comes in is through Diana Walsh.
and they did not list her as a witness. So even if there was evidence that the government was planning to introduce that Mr. Walsh supplied the name, that doesn't indicate he paid for it, knew that she finally did it, was interested in the results. The evidence we do have is that the mother saw a psychic, and even the the evidence suggests that when Mr. Walsh was speaking to other people about it, he was dismissive of it, and even told his wife about it. So I don't think it's appropriate that they get to introduce the contract or the fact that Diana Walsh hired a private investigator on the 27th unless they're going to call a witness to link it to him and that he knew about it, wanted it, and was invested in the results. Otherwise, it's not relevant.
So, Your Honor, you were right about your memory of the grand jury testimony. That statement of the defendant giving the name Axios, that comes from his mother. So
But you don't have her on the witness list, so how do you make that connection without her?
that's fair. We were suggesting it was a reasonable inference by the amount of contact the two of them had, and that he saw her frequently, and that he talked to her frequently over the phone. But again, we were trying to be very limited with what we were entering. It was just the contract through the private investigator. So with that, I think Ms. Porges, her assessment of the evidence is correct. And so I don't want to belabor this issue. That was the only thing we were trying to get. We were not trying to get any statements of the defendant, nor were we trying to get any statements of his mother, simply the contract.
Well, you make whatever strategic decisions you're going to make, but that may lead for a paucity of evidence on linking his knowledge to it. That's your choice.
Understood, Your Honor.
All right. Number 17 is paper number 203, and no objections to the calendar.
There isn't, Your Honor, but given the fact that my understanding is that there's going to be a blank calendar and items or notations may be placed on it, and I'm assuming then that is going to go to the jury. If that's the case, then the defendant would also like access to also add or denote things on that calendar. We can color code it, we can figure out a way, but that's what I would ask for. Or we can have 2 calendars, which seems superfluous if there's one.
We were just looking to give each juror an empty calendar so they could make their own notes and it would be part of their notebook, not something like that witnesses would be using.
So if
Okay.
they just want to give a blank calendar to the jurors so they can keep track of days, then that's fine.
Yeah,
Yeah, it just got confusing during the grand jury.
all right. 206 is allowed, sequestration of witnesses. 207 is a review. Commonwealth took no position.
Your Honor, may we be heard sidebar?
Yes.
Your Honor, with the court's permission, is it okay if Ms. Walsh comes back in?
No objection.
Sure. So paper number 208, which is now moving to, did move at paper number 206 to the defense's motions limine. Paper number 208 is defense number 3. That is now mooted and requires no ruling. Paper number 209, defense 4. Commonwealth has indicated they will not seek such opinion, so no ruling is needed. Paper number 210, defense number 5. Commonwealth will not seek, no ruling is necessary.
Your Honor? Might we ask that a similar order regarding any awards or commendations for any defense experts that may be called? That they may not elicit that from those experts?
Well, to the extent that it goes to their qualifications, they need to do that. They need to know that the person's qualified, but no excessive lauding. How about we say that? On either side. Paper number 6, defense's motion in limine regarding any opinion that the defendant knew about the extramarital affair, and that was opposed by the Commonwealth at paper number 230. And as I understand the respective positions of the parties, is the Commonwealth's position is it's not seeking an opinion as to that, but is going to plant breadcrumbs such that a jury could, or could not, but they're hoping they could, infer the same.
That's right, Judge. They've told us they're not eliciting an opinion, so that
Right.
answers that.
So that seems to be the line that the rules of evidence draw as well. Paper number 7, defense number 7. What did I write here? Is paper number 212, and it's regarding opinion evidence, and the opposition was at 231. And I wrote to myself, what more do you want? And under what authority?
Well, all I'm trying to do, Judge, and all we're trying to do is keep these witnesses from taking the stand and start offering opinions as opposed to the facts of their investigation, that they not be asked opinions that they have not provided in all of these reports. Because when you read through the hundreds of pages, and what they've given us is all this search data and everything, that's fine. But they can't then elicit, do you have an opinion about what this means? They can't do that, and that's why we filed this motion. That's all.
I'll hear from the Commonwealth.
Thank you, Your Honor. Your Honor, we've provided voluminous discovery in this case. Certainly, we expect that the witnesses will testify as to what they did in conformance with their reports. They'll explain their reports to some extent, but the defendant has all this material that has all been provided. So we would, if there's something specific they're looking for, but again, the witnesses will not stray beyond the reports that have been provided.
All right, then we have no disagreement. As an aside, by the way, it is somewhat surprising to me as I was looking at this issue how little is said about experts in the context of, or how little is required by the rules in stark comparison to the civil rules. And I can't resolve that in my mind why the drafters of these rules sort of make a heavier burden on the parties in a civil case with regard to expert testimony than is expected in a criminal case. I don't know why. Curious.
If I may?
Yes.
I suspect it's because in criminal cases you have procedural due process bumping up against substantive due process, and that's not present.
Would you think that that would then err to the side of more disclosure for the defendant?
I think less because fair trial strategy, and that might be different. That would be my thought.
My thought when I was sitting in the back is why don't they have to produce what they have to produce in a civil case? But I don't write those rules. I just try to interpret them.
I don't want to belabor this point at all, but I remember Stephanie Page filing motions for depositions because you allow depositions in civil cases.
Right.
And we were always shut down saying no, and we asked the same question the court's asking.
Well, I'm asking that question, and I almost never allow depositions in a civil case, even of the experts, but regardless. It's just a curiosity. Anyway, defense number 8, paper number 213, opposed at 232, and then another rebuttal at 281. To exclude defendant's request to consult with an attorney or statements of prior counsel. And I got more on that today, I think, too. Let's pause on that one. Bad acts, 214, paper number 9 for the defense. I think we've discussed this. It's opposed by the Commonwealth in a partial opposition at paper 233. And I had written to myself in my notes, question to the defendant specifically, what additional statements from the recorded interview does he want to exclude? But we're going to get to that in a minute. Paper number 215, defense number 10, motion in limine regarding witness characterization of evidence or of the defendant's behavior. The Commonwealth has said it will not seek character evidence, but will offer evidence of the defendant's behavior through observations. Is that right?
Yes, Your Honor.
All right, that seems reasonable and likely where the line's going to be drawn. Number 11, paper number 216, asking the Commonwealth to designate and provide notice of specific statements and internet searches contained in the digital data seized to be introduced at trial. Anyone wish to be heard more on that issue?
Your Honor, the Commonwealth did file a response to pleading paper 234.
I saw that. I will say that the Commonwealth's opposition at 234 seemed to take a reasonable approach, and likely where the line will be drawn. Is the pillowcase and the pillow, that's all over, right? There's nothing there.
We're not going to introduce it, Your Honor.
And there's nothing other happened with regard to the, this is just a hanging, dangling from the prior motions, the dinosaur, teddy bear, that's nothing I need to worry about.
Nothing you need to work on. We sent counsel a list of photos we were intending to introduce. I think that we cropped out any images like that, and so if there's any issues, they'll let us know.
All right. So how do we take on this, what the remaining issue that I really want to address today, and then I'm happy to talk to you about anything that you need to discuss with the court, is these transcripts. And I had about 5 minutes to look at the case that the Commonwealth has now cited in its most recent briefing of this morning, and I want to give it a closer look. But one way that we can approach this is to literally go line by line. I know that the defense has indicated, and I appreciate the way that this was laid out in the briefing, because it makes it very clear as to what it is that you're seeking and helpful. So I appreciate the work that you did to get that in that shape. And you've stated your objections. So one way I could do this is to just go through on this list that you gave to me and rule at some time between now and before the evidence is played, and give you a little bit more time to brief it. I will say that as I said to you at the side of the bench on Friday, but I think that there's a evidentiary issue that needs to be decided with regard to what the scope of the employment of Ms. Minor was. And I'm not sure how this new law fits within that analysis. If it does, if it's just a separate analysis, it almost seems like it's a separate thing completely. And a separate vehicle or avenue to admissibility, these adopted admissions. But I want to give the defense time to respond to that because it just came in this morning. And as to many of these statements, and so that you don't misunderstand where I thought I was on Friday, which was alerting you to the issue of agency, I'll call it. And I don't want either of the parties to be misguided by what I said to you on the side of the bench with regard to that. And what I mean by that is this. Even if Attorney Minor's statements aren't coming in, even if they weren't coming in, I never intended to not allow the Commonwealth to tell the jury that she was present there. So whether her statements come in is very different than whether her attendance at the interview was going to come in. And I think in the opposition that I saw, the papers that I saw flying, I think the Commonwealth, maybe based on what I said at the side of the bench on Friday, thought that I was excluding the latter as well, that is, her attendance at the interview. I also want to remind you of something that I said at the side of the bench on Friday, which is much of what Attorney Minor says is repeated by the defendant. And so the cumulative impact of those statements is not significant for the most part. There may be statements that she makes that are significant. It seems to me, and I'm sure the defendant is going to ask for, the humane practices instruction. And if that is the case, it would seem to me that the dynamic of what is going on in that home during those interviews is relevant to that, specifically Thomas's role. I see you nodding your head no, but then I get to the later interviews. Maybe there's not enough in there for you to care about it. So why are you nodding your head no over there, Attorney Tipton?
I appreciate the time to respond. I was reading their cases at 4 a.m. That's not the best time to be reading cases. If the court...
I was blissfully ignorant of it at 4 a.m. I didn't see it until 7 a.m.
So if the court's... we will file a written response. My understanding is the court's going to give us time for that. And when's a good time to have that filed? You said you would make a ruling before the evidence started, so
Right.
I'm just wondering...
I mean, honestly, the next couple of days, we're going to be busy with picking a jury, and maybe even longer than that, so, I mean, I don't, as long as I
By
rule on it,
Friday.
yeah, as long as I rule on it in time for you to make the appropriate edits, and I don't ruin, you know, the poor IT person that's going to be tasked with doing the edits, Thanksgiving. How deep into the case are these transcripts coming in?
Potentially the first day, Your Honor.
Well, great, thanks.
But the good news is like you said, a lot of it was cumulative. And so in going over that, particularly the interview in the 7th, when we looked at it, we're like, there's really not a big problem with a lot of these. So we'll start working on some of those redactions. And we gave a list to the court of the things that we didn't object to. So we're going to start working on this.
So curiously, and I just want to make sure that this was a conscious decision on the defense's part and not something that was unconscious. There's some of what she said that you kept in. You know that. Well, attorney,
No,
there are some statements that you did not ask to be, and so,
from Tracy Minor, Judge?
yes.
Well, then that was an error. That's the highlight didn't carry through.
Okay, all right.
Because, and I don't want to interrupt the Commonwealth, I'll just, and we're going to file a written response. Let me just lay the groundwork for it, though.
Sure.
The court brought up the humane practice. We footnoted in a pleading. We never asserted humane practice. We're not asking for humane practice. Okay?
All right.
That is the bottom line here. And the Commonwealth's citation to sheriff in their latest briefing, they misstate what the law is. The law is if humane practice is a live issue, the court is required by law to give it humane practice. It's not a live issue. We've never raised it. So I want to set that groundwork.
All right, I appreciate
now.
that.
2, I understand what the court just said about you never intended to indicate you were going to exclude the presence of Tracy Minor. Our prejudice, contrary to what the Commonwealth argued in their brief, in their memo they filed last night, We made it very clear what the prejudice is. The prejudice is from the fact that Tracy Minor is there and all these statements are being made. Not the statements necessarily of Tracy Minor, but the statements of the client. And we made clear what we think the prejudice is. And that prejudice, once again, we'll lay it out in more detail, but that prejudice is the same type of prejudice that flows from the Commonwealth's reaction to Proctor and I won't go into anything about Proctor except for the fact that once Proctor's integrity was impeached, the Commonwealth moved away from him. Why? Because his impeached integrity reflected on this office, the Norfolk County District Attorney's Office. Our prejudice is that what happened at these interviews, that Tracy Minor was there, that the jury can take that to say, as we said, either he's lying to his attorney, therefore he's lying to us, and they can't believe our representations during the trial, or his attorney was complicit in the misrepresentations he was making to the police because she chimed in, but she was there, and so now we're making misrepresentation on his behalf. That's the type of prejudice we're trying to avoid, and finally, we're going to be arguing, why is it relevant, especially when you take the humane practice out of it? There is no relevance to Tracy Minor being there. So we'll brief it, but I wanted to lay the groundwork for that.
All right. So I appreciate that preview, and I appreciate the reminder with regard to the humane practices, both for myself and also to the Commonwealth as we move forward and try to resolve this issue for you.
And could I just make one more suggestion? If the Commonwealth could take the highlighted sections that we provided to the Commonwealth and you.
Yes.
And just now, go take those highlighted and maybe color code all of these statements they've listed. Wouldn't it make it easier for us all?
Well, I think we can get down to, I think if you get rid of the cumulative stuff, you're really probably down to not a lot.
Right.
So that might be a good idea. What do you think about that?
I think you're right, Your Honor. I think that the issue became with the transcripts. Once you started taking her out, it became confusing. So she would actually ask a question and he would answer it.
Right.
Or she would correct him on the restitution figure 3 times in a row. So then he's just shouting numbers out and it doesn't make sense. So a lot of it was just confusing with what was being proposed. So we're trying to go back and be more strategic about this.
All right. And so my goal is to make things clearer and easier for the jury
Yes.
than confuse them. And so to the extent that that you're having that situation where there's a question that she's asking that he's answering, and it's cumulative, the relative prejudice, I understand the argument, and I'm not ruling on it right now, Attorney Tipton, because once she's there for one answer, she's there, your argument is going to be the prejudice attaches. I understand the argument. But it's also incumbent upon me to provide evidence to the jury that they can, in a manner that they can consume it. And if it's doing so, once I balance the prejudice in a way that allows them to digest the evidence, but I'll think more about the prejudicial issue. And maybe you can get, there really is not a lot that she says that he doesn't repeat. So how about Friday on that color coding?
Yes, Your Honor.
All right? That's all the motions eliminate, right?
Yes, Your Honor.
All right. So, not much else that I have other than The jurors that were called in today were being used for a civil case. They're going to be told at the end of the day that they're being held over till tomorrow, and that's so that we will get a big yield tomorrow, and hopefully I'm hoping to take 70 of the jurors tomorrow, and the remainder will go hopefully to Crim 2 so that they can get their work done too. And then every day they're going to be held over, so we will have jurors right through till Friday, because as you know, typically we don't get jurors on Friday. And we'll seek to 16. Any questions that you have lingering that you need answered between now and tomorrow morning on anything?
No, but I would ask kind of sidebar on an unrelated matter to this case.
Okay.
When it's on.
Anything the Commonwealth needs?
No, Your Honor, I think that we'll work together and try and figure out some of the other issues we've talked about today. I've been keeping a running list and just trying to make sure that we stay on schedule.
All right. I will see you at the side of the bench. So the plan is we'll see each other. We'll end today's work. I appreciate the commitment to do some further work on issues, but I think we're really in pretty good shape
Yes, Your Honor.
as we move forward to the start of this. I will get you later this afternoon what I believe is the most updated witness list, which will be attached to that supplemental questionnaire. Take a look at it carefully, and I made some changes, some other minor changes that you'll see in there.
And I think we'll be able to give the court the binders of the internet stuff with spreadsheets of the isolated ones that we're looking at.
All right, that sounds good.
Thank you, Your Honor.
Have a good day, and we'll see you back here at 9 o'clock tomorrow morning.
You as well, Your Honor.
That was continued to November 18th at 9 a.m. Thanks, everyone.
No? Okay. I like to keep it simple, Madam.